Welcome to Boring Topics. Today we'll be taking a look at an increasingly prominent feature of the American political landscape, the Supreme Court of the United States. The Supreme Court has come back into focus recently as it's handed down some major decisions and had one prominent member announce his resignation just this past month. Justice Kennedy was a moderate whose swing vote moved from either the liberal or conservative bloc on a case-by-case basis. Unlike many current and former Supreme Court justices, Justice Kennedy didn't have an overriding philosophy of jurisprudence, such as Justice Thomas's or Scalia's constitutional originalism. In general, Kennedy's vote usually allowed either faction to achieve the needed 5-4 victory for any given case. It may seem odd that in a representative system of government, so much depended on the vote of just one man. Let's take a look at the Supreme Court's origin, its growing role in the governance of the United States, and how it functions. When the Constitution was drafted, the founders created three separate but equal branches of government: the legislature, executive, and judiciary. Each have their own responsibilities under the Constitution. Broadly speaking, the legislature drafts the laws, the executive branch enforces the laws, and the judiciary interprets the laws. Constitutionally speaking, Article 1 lays out congressional duties, Article 2 lays out the President's responsibilities and powers, and Article 3 lays out the format for the Supreme Court. The Supreme Court is the highest court in the land, with Congress having the power to establish what the Constitution calls inferior courts or subordinate courts underneath it. One little-known fact is that Congress even has the authority to limit the jurisdiction of the Supreme Court, essentially what kinds of matters the court can consider and rule on. Sitting at the apex of the judicial system, the Supreme Court has 12 regional courts underneath it, plus a non-geographic 13th court, which have 94 judicial districts underneath them. Outside of a few special situations, cases do not start in the Supreme Court. Rather, they begin in the lower courts and move their way up through the various levels of the judicial system until the Supreme Court is the only level left. Until the Judiciary Act of 1891, the Supreme Court was required to render a verdict on all cases that reached it. The 1891 Act created 13 circuit courts underneath the Supreme Court, whose decisions are generally final. While the Supreme Court can review decisions made by the circuit courts, they rarely do so, typically only when there is a constitutional question at stake that several circuit courts have ruled on differently. Further refinements were made in the Judiciary Act of 1925 and the Supreme Court Case Selections Act of 1988. As a rule, there is no right to be heard by the Supreme Court. A party who wishes to ask for a hearing before them must submit a petition for certiorari, which is printed as a booklet and 40 copies filed with the Supreme Court. That by no means guarantees a hearing before the Supreme Court, as at least 4 justices must agree that a case is worth a hearing, known as granting cert. The Supreme Court consists of 9 justices, although the Constitution is silent on how many justices are supposed to comprise it. There were 6 justices from 1789 until 1807, when a 7th was added. Then it jumped to 9 in 1837 and reached an all-time high of 10 in 1863, before settling back to 9 in 1869. This ambiguity has actually been exploited by a previous president, Franklin D. Roosevelt, who in the late 1930s threatened to pack the Supreme Court with additional justices who would rule favorably on his agenda. While he ultimately did not follow through on his threat due to the Supreme Court starting to rule favorably for his legislative agenda, the possibility remains that additional justices could be appointed in the future. As mentioned, justices are nominated by the president and must be confirmed by the Senate before taking office. Justices serve for life until they either die in office or resign. There is a provision to remove a justice if Congress finds them guilty of not exercising good behavior, but a justice has only been impeached once. This was Samuel Chase in 1804, and he was acquitted by the Senate in 1805 and remained in office until his death in 1811. Almost since its inception, the Supreme Court has wielded broad and sweeping power to overturn laws it finds unconstitutional. In the early 1800s, the case of Marbury versus Madison gave the Supreme Court itself the power of judicial review of any federal legislation. This power has grown over time as the most controversial legislation, particularly ones that deal with constitutional interpretation, eventually find their way to the Supreme Court. This has given rise to judicial activism as the Supreme Court has sometimes not only struck down, but also instructed and interpreted in what laws should say. This has led to a president's appointments of Supreme Court justices being one of his most important, powerful decisions. Also, it has led to increasing political polarization in the Senate, with either party out of power attempting to resist the sitting president's picks. In general, though, a sitting president typically gets an eventual pick to the Supreme Court. With the retirement of Anthony Kennedy, we will once again watch the process of a Supreme Court justice being selected by the president. And with 2018 being a year where congressional elections are taking place, the selection and confirmation of a new justice just became even more political.